first case to come before the court is State of Ohio, City of Akron versus Susan Hayes. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time, please let me know, as I'll be keeping track of time. The arguments are being recorded, so please introduce yourself, keep your voices up, stay behind the podium. You should not use the names of children or victims or minors during your argument. You can refer to those folks by initials or general terms. The judges have read your briefs, I assure you, and are ready to proceed when you are. Would you like to reserve time?
Yes, Your Honor, I'd like to reserve 5 minutes.
Very well. You may start when you are ready.
Thank you. Good morning, Your Honors. Andrew Whitaker on behalf of the appellant. I have, as the court saw, I entered a notice of appearance replacing our original attorney from the Public Defender's Office, Ms. Susan Manofsky. Good morning, counsel. We're here today to discuss the contempt conviction of Susan Hayes. And I think it really is most beneficial for me to focus on the few areas that I disagree with the city on, because there is quite a lot of agreement between the briefs. There's certainly an agreement between the briefs that Ms. Hayes was entitled to due process. There's an agreement between the briefs that Ms. Hayes was not afforded due process. And so I think that the areas of disagreement are in the manner in which she was not afforded due process. I would say that Ms. Hayes' position is it's a greater scope that the court failed to provide due process in. Additionally, I believe there's a disagreement on the second assignment of error, which is the sufficiency of the evidence. So I'd like to begin just by touching briefly on the due process argument.
Attorney Whitaker, before
yes.
we get into all the arguments, would you consider failure to appear to court direct or indirect contempt?
I would consider that indirect contempt, Your Honor.
And is there case law that they define it as direct or indirect contempt that you know of?
I don't have a cite, Your Honor, but I believe the case law supports the proposition that direct contempt must occur in front of the court. The court witnesses the contempt. Indirect contempt would be the failure to appear. By its face, it is something that not occurred in front of the court.
Doesn't the court see that the defendant is not there?
I think that there is certainly no evidence that the court saw that. As everybody knows, many times the court does not get called into session for pretrials, and that's what this was noted as. It was not noted as a hearing. And so when the court does not come into session, it is not on the record then and in front of the court. Regarding the due process violation, the city agrees that the defendant in a contempt proceeding is entitled to notice of the hearing, an ability to prepare, an ability to present evidence, and counsel. And here only counsel was provided. This was noted, as the record makes clear, as a pretrial. There was no notice that this was going to be a hearing on contempt. There was certainly no ability for the attorney to prepare, to have and present evidence. In fact, you see in the transcript that the defendant, when she's talking, is talking about all these medical things that she could have gotten evidence of, but they did not know or have noticed that there was going to be a contempt hearing. And I think that the attorney for Ms. Hayes makes that very clear on the record. I think that one thing I would disagree with the city on is that because she spoke, there was some sort of de facto hearing. I mean, we see over and over again when she is trying to explain, the judge says, I've had enough, I've heard enough. He says on multiple occasions, I got a good flavor of it, I'm good, I think I got it, yeah. But he does not even allow her to finish what she wants to tell him, despite the fact that it was against the advice of counsel to proceed without the proper notice. She does try to say some things, and the judge continually interrupts her.
She has the right to remain silent as well.
She absolutely.
You can have a hearing without the defendant speaking, correct?
Absolutely, absolutely. However, in this case, not only was there no notice that there was going to be a hearing on these issues, when she did try to say something, and she was exercising her right to speak, which she also has a right of, did interrupt her.
And what was the state's burden in all of this? Was the state required to prove contempt, and did they do that? Did they present?
The state presented nothing, Your Honor. The state remains completely silent on this issue. The judge appears, from what we can tell from the record, to have reviewed criminal case file. In fact, the only thing he discusses in terms of the dates that were actually missed, he's referring to the criminal case number CRB, 18 CRB 6826, and notes several dates that were missed in that case.
But contempt isn't a criminal charge. It's an enforcement of a court order or a coming to court. So the burden isn't on the prosecutor to prove it beyond a reasonable doubt. There's protections when you're talking about criminal. Due process depends on if it's criminal or civil contempt. So the prosecutor wouldn't have a burden here, right? It would be all about the defendant violating an order or.
The prosecutor still must present evidence that there was an order and that that order was violated, and neither of them was done here. There was no evidence presented. Certainly the court can call its own witness. The court could have had somebody from the clerk's office come and testify to a court order, to the fact that it was missed that day, but there was no evidence here presented at all to support a finding of guilt on this issue. And while it is quasi-criminal, they are still entitled to the due process protections that they are entitled to in a criminal case.
So a judge couldn't have a contempt hearing unless there's a prosecutor present presenting a case?
I think that the court could call its own witnesses. A court always has the ability to do that. And if the prosecutor chose to remain silent, certainly that would be the prosecutor's right. There would still be evidence presented to the court. I don't think that in any case, if the court proceeds and calls its own witness and takes evidence, then a burden has been met. But there is still a burden that falls on the state in this matter to present that evidence.
And maybe you already said this, Attorney Whitaker, so forgive me, but here, was there a charge for contempt that was in writing that also included not only a failure to appear, but an obstruction of justice?
There was not. In fact, the only charge that we see, arguably, and certainly Ms. Hayes disagrees with whether or not it is in fact a proper charge, but the only attempt at a complaint we see here is the complaint / warrant that was a part of the record from Akron that indicates that defendant Susan Hayes did something on August 12, 2020. None of the different options for what she actually failed to do are even checked. So the complaint itself, beyond not being signed or sworn, doesn't even indicate what conduct was believed to be the basis of the contempt. And there's nothing about an obstruction in any of the documents.
Thank you.
Would you agree Akron Municipal Court is unique in the sense that they do it as a separate file and charge of contempt?
I would very much agree that that is a unique situation, Your Honor. It is, as far as I know, none of the other municipal courts that this court sees cases from do it this way. When somebody fails to appear, they may issue a vet warrant, bench warrant, revoke bond, things like that. But a new criminal case noted on the case cover as code 000 is not something that we see in any other court. And I think that that is how we kind of end up in situations like this, where they are new criminal charges and then, or quasi-criminal charges, and the due process that is necessary to be afforded them and the sufficiency to prove these is lacking. In terms of other due process that I believe Ms. Hayes was denied, as I indicated just briefly, the complaint and the warrant itself, even what the city agrees is necessary here, that it is a written charge that is placed on the journal and it apprises the defendant of what they did. The document that they refer to here is woefully insufficient, even in those minimal areas. And so I think that even in what the city is indicating they think is necessary, while they believe it's here, I think a clear reading of the document that they refer to, first of all, refers to August 12th as the day that this alleged contempt occurred. There is nothing in the record of any hearing order to appear at all on August 12th. They indicated a footnote, well, the judge must have, or somebody, whoever filed this, must have meant August 10th. I'd like to first note that unlike many complaints and indictments we see, it does not say on or about August 12th. The complaint, it says, or the purported complaint says on August 12th. Additionally, the only indication that there's some August 10th event is an unsigned even initial note on the jacket cover of the traffic case that there's something that says, I believe it says, just to make sure I'm speaking correctly, it looks like it says 810 PTPD. The city surmises that means pretrial public defender. That may. Certainly there's nothing in the record explaining that. There's nothing in the record indicating that this was an order, or certainly nothing in the record indicating that anybody was given any notice that this was a court order. The only things in the record that can be identified as notice of any dates is a date that she signed for a pretrial earlier, and then there was an actual notice from the clerk's office that was issued for her to appear on July 7th, 2020. So there's nothing in the record indicating that she was given anything that apprises her of the conduct for which she's alleged to have committed contempt. Additional.
I should let you know that you're moving into your rebuttal time.
Okay, thank you. I will try to wrap it up. I'll move very briefly, Your Honor, to the sufficiency. And I think that that also goes to the due process. Part of due process is whatever level, whether we're talking beyond a reasonable doubt, preponderance, none of that was provided here. The court did note some dates missed in a criminal case, but there was nothing put into evidence about any dates that were missed as it relates to this traffic case. And that is the only case that is in front of this court, that is the only record that is before this court. The state has to admit in their brief that it looks like maybe the judge thought that she had pled guilty earlier. There's not even a finding of guilt here. He just takes notice that she missed those dates in the criminal case and then moves to
So
sentencing.
is this a criminal charge? It's even under the provision called special remedies. You have protection because there are criminal penalties involved with this special remedy, but it's not a criminal charge.
And I understand that, Your Honor. What I'm saying is those protections aren't even met, because here, the judge doesn't even make a finding that in this case, she ever violated a court order. He refers to dates that were scheduled in a criminal case. Those dates, none of the ones he discussed, August 8th, August 23rd, October 5th, and November 14th, are in any way related to the complaint that the city alleges is at issue here. So even though it's a quasi-criminal, it doesn't even meet those protections or the sufficiency under any level of review. And I thank you.
Thank you. You will have a little over 3 minutes and 15 seconds.
Thank you, Your Honor.
Good morning, Your Honors. Brian Brewer. I'm here on behalf of the City of Fairlawn. It's a little confusing based on how this case ended up here, whom I'm actually representing. Judge Landler, to answer a couple of questions you raised, there is case law that says that failure to appear is indirect contempt, and I did not cite them in my brief. I did not think to do that. I apologize for that. But there is case law that does say that failure to appear is indirect, and the idea would be that direct contempt is something that actually obstructs the court's proceedings that's happening in the moment, and you need to correct it right then. Whereas indirect, a failure to appear could be justified by a number of different reasons, such as a car accident. So that's why that reasoning would be there.
Thank you.
And then as far as the issue, this was a criminal contempt finding ultimately, because there was no way to cure the penalties here. Ms. Hayes was sentenced to 30 days house arrest, which she has served. She was ordered to obey all laws for 1 year, which that passed a couple weeks ago, and she was ordered to pay court costs. The court costs are outstanding. And they are a fairly small amount, but that is all that is left at this point on this charge. And listening to, I think the questions, I think that some of the issue that's you're raising reminds me of something that I had a conversation with the judge when I worked here at the 9th District. I was really criticizing a municipal court judge for not doing something I thought technically correct. And the judge looked at me and she said, Brian, you have to understand municipal courts are dealing with a million things on a given day, and you're putting out fires all the time. You need to treat them with grace when you look at what happened here. And so while I can see that what happened here was not a textbook contempt hearing, and probably needed to have a little bit more to it, I don't think that this was coming from a place of I think this was coming from a place of trying to do justice. If you read what the court was doing, the court was reviewing Ms. Hayes' record in a number of different cases and said, you have 5 different contempt charges. And then the court went through them and said, I'll find you guilty on 2 of them in order, she got sentenced to the harshest penalties here, that she would order to pay court costs in another one, and then the court dismissed the other 3. So this was in some ways the court trying to work with Ms. Hayes to try to hold her accountable, but at the same time not overly punish her. And that's some of what I think led to this hearing occurring in the manner that it did, because Ms. Hayes did speak up at the hearing and say, I want to get this over with. I don't want to have to come back here. And she said, I have problems remembering court dates. I don't want to basically get into a situation where I have to come back and I miss it again and then I'm going to be tempted again.
And did the attorney actually give a good reason why it should be continued? Because basically, it sounds like the basis of it was that she missed X and X court date. What was the reasoning? Was there a continuance requested? And if so, what was the reasoning?
There was a continuance requested. Ms. Hayes' counsel objected to a lack of notice about the contempt proceeding. And the court's position on that was that you knew that this charge was out there. You should have known that we were going to move into this. And another point I wanted to bring up as well that was touched on here is that the existence of a court order that Ms. Hayes violated. If you look at the actual record on the appeal, you'll see I filed something, a motion to try to correct the record. And the reason I did that is that there is an order that exists. It, however, is not part of this record on appeal. And the reason for that, as far as I can surmise, is that Ms. Hayes had 4 or 5 cases in the municipal court that were all being treated as consolidated, but they weren't. And so when the court issued an order, the court put all the case numbers on it, and then it only got filed in the criminal case, which is not the case before you here. And I asked the municipal court to correct the record. The court did not act on that motion, and so that is not in the record before you, but that is kind of where this is. Again, the court was looking at something, when you read the transcript, the court was clearly reading something about a date in the record, but it just isn't part of the appellate record here. And again, this goes to it being a municipal court, it goes to the way that the clerk's office docketed things and filed the court's orders, and unfortunately that's kind of where we are at in this case. And that's one of the points I tried to make in my briefing, is that we believe that this is probably reversible error. And I recognize the court's going to do its own review of the record and come to its own independent determination on that point, and that my concession is not the end of that analysis. But the point I would say is that the errors here that we don't agree on a number of the points that are being raised by the appellant regarding the sufficiency of the evidence. First of all, that assignment of error is a single sentence. It's not argued. This articulation about what dates the court was actually considering is not in the briefing, and therefore it wasn't actually a developed argument, and it should be overruled on that basis. And if you read the record, Ms. Hayes is not limiting herself to those dates necessarily. And if you review the record that was before the court, there was sufficient evidence, if you believe it, to support a finding of contempt here. And again, this was not the ideal proceeding, like the way that this went through it, but it was the court trying to work with Ms. Hayes led to, I think, this being a little bit more of a haphazard proceeding than it should have been. And then regarding the issue of the notice and whether it needs to be sworn, the appellant hasn't really argued that today as much, but this is a quasi-criminal proceeding, it's not a criminal proceeding, and inherently a contempt proceeding has to arise out of a case where the court already has jurisdiction. Otherwise, there would be no order that you could enforce. So the idea that the court needed to sign an affidavit or a sworn statement in order to invoke its jurisdiction on a contempt proceeding is not correct. That's why the criminal rule 3 argument doesn't apply. The statute only says it needs to be reduced to writing. And in this case, there is something that is reduced to writing and filed with the clerk. It's the notice of contempt, and then which is on the same page as the arrest warrant. And the judge signs the arrest warrant, but there's a line for the bailiff to sign up on top for the notice of contempt. That's not signed, but again, that's not required by the statute itself. And the contempt notice does say failure to appear on August 12th. So it did notify her about what she failed to do, and gave a notice of what the charge was, so they comply with the statute. So the issue here is really just what did the court need to do on the day of that hearing? Did there need to be testimony? And this court's precedent indicates that yes, there needed to be actual witness called, testimony presented, or something along those lines. And that's really the only issue as far as we're concerned, is that there was jurisdiction, so the court could proceed with the contempt, and then there was sufficient evidence to find the contempt. It's just a matter of how did it end up between those 2 points, and needs to probably go back for a hearing on that issue. So unless the court has any questions, I will yield the rest of the remainder of my time.
Very none, thank you so much.
Thank you.
You may proceed.
Thank you. Briefly, in 3 minutes and 15 seconds. First, I'd like to say, this case isn't about whether we think Judge Hamilton had nefarious motives or not. The case is whether or not this case is about whether due process was followed in this particular case. I'm certainly familiar with the busy pace of a municipal court. It is, in fact, where most of our citizens come into contact with the justice system. That makes it more important that things are followed the way they should be followed. This is where people get their opinions of our judicial system. This is where they begin to develop that respect for the law. And if the rules aren't followed there, it does not send a good message to our citizens. So I think the fact that it's busy and it sees more people is in fact the reason to make sure we're doing things correctly. In terms of the city has argued that there was sufficient evidence because he was clearly reading something about some dates. What we have is the record before us. We don't have a record of a different case. We're not able to look into the camera and see what Judge Hamilton had on the bench. What we know is what's put in the record, and the only discussion of misdates that is in the record that Judge Hamilton indicates he is relying on are the dates he listed under the criminal case. And those dates in the transcript, none of them have any relationship to either the complaint that the city points to or any documents related to the traffic case that this is an appeal from. And then finally, the city argues that this alleged complaint is sufficient because it says that it indicates there was a failure to appear. No, what this complaint does, and if you look at the complaint, is there are 1, 2, 3, 4, 5, 6, 7, 8, including other methods that can be checked that contempt is completed. Failure to appear, failure to pay fines, failure to appear for days, all these different ways that you have failed to come to court to do what you're supposed to do. And then it moves to which willful contemptuous failure to appear did obstruct the due and orderly process of judge. But the manner in which that occurs is not checked here. This does not indicate, the face of this complaint does not indicate the conduct for which she is being charged with contempt. So it does not, in fact, apprise Ms. Hayes of what it is she's accused of. So even under these lower standards of notice and what she is entitled to for due process in this quasi-criminal, this does not meet that standard. Thank you.
Thank you. Thank you both for your presentations. The court will take the matter under advisement, issue a decision in due course. We will have the clerk of courts mail a copy of the decision to you on the day it's released, and the opinions will be posted on the Nevada Supreme Court website. Thank you.
Thank you.